the Appropriation Act has been sent, or the budget bill was sent to you. Now, you cannot say because you do not agree with the Senate and the executive in the appointment of the DG, therefore you will serve a whole important aspect of the administration. You will serve it of funds. I think it's not the right way.
Until, I mean, there's a condition to that.
Yes.
You heard what Honorable Wajabiamila said about, you know, saying he doesn't agree with the president. It's the president's refusal to act on a resolution that has forced them to do that. And they're saying, until you act on our resolution, we withhold, we reserve the right to exercise this power.
Yes, the Honorable also knows that resolutions of the House do not bind the executive. It's only the laws passed by the National Assembly that binds the executive. Yes, resolutions are meant to be respected by the executive. But again, if you now...
Would you say that some respect has been shown to this particular resolution?
You see, it's also a question of what is the content of this resolution. If your resolution is meant to indict perhaps the executive and also the Senate when they think they are right, so it's now a two-way thing. Ego also comes in. And also administrative convenience also comes in. So would you now say that they should obey the resolution of the House when it is a head-on indictment on the Senate and also on the ESCO? So you see, it's and again, if you think that you are right in terms of your proposition that she was not qualified, we could go to court, find out what should be the qualification. Since it's an issue of qualification, it's an interpretation of statutes. Actually, what they are talking about is interpretation of the statute.
Well, if you talk about interpretation of the statutes, do we, because maybe of an individual or a particular agency, try to amend the Appropriation Act? Because in all of this, look at what is being done. The Clause 10 inserted in the 2013 Appropriation Act, and I'll read it. It says, quote, all revenue, however described, including all fees received, fines, grants, budgetary provisions, and all internally generated and externally generated revenue shall not be spent by the SEC for recurrent or capital purposes or for any other matter, nor liabilities thereupon incurred, except with prior appropriation and approval by the National Assembly. So, with this, they say they were trying to give, the powers to the National Assembly so that things like this can't actually go, escape their oversight.
Yes, again, when you look at the Act too, and you also look at the reason, you know, remember there was a budget crisis.
Absolutely.
That is when the president refused to sign, because it said that some of the provisions of the budget bill was meant to also impede the function of the executive. That some of the provisions actually violated the Constitution. So there was this crisis and there was a way out. They said, okay, sign, but let's come back and discuss.
So in this case, what do you think should be the way out?
No, the way out is, one is that if the presidency or the executive and the Senate feels that the exercise of discretion in appointing the DG of SEC, that it is right, they should first insist on their rights. Now, if the House of Representatives now feels that they did not do proper interpretation of that act in the appointment, they should go to court and seek for interpretation on the appointment of the DG, since that was just their ground. So as to be sure, because tomorrow we have to do this for posterity's sake. Mm-hmm. Tomorrow something again may come up. Again, you know, remember there were ancillary issues of corruption that came up against a member of the House. Now, that one is still there. Are we not going to say, or can't we make an inference that it was because of that she's been intimidated?
You know, if you're going to go back, if you're going to toe that line of issues of corruption against a member of the House, you also have to bring about the issues that were raised concerning Ms. Oteh's operations in the SEC.
Yes.
The fact that she was taking certain decisions without carrying the board members along, and the board members even came up to complain. The staff of the SEC also had protests, I think 2 or 3 protests, asking that she be removed. Yes. So if you want to toe that line of the issues of corruption against your member, what about the issues that were raised about Oteh?
Okay, that one is an issue of administrative discretion or administrative incompetence.
Okay, so
yes.
Now, so on issues of administrative incompetence, should she still stay?
That becomes a new issue. if you raise that issue, if there is a finding of fact of administrative incompetence, that is also an issue that goes to the Senate so that she can be properly removed. That's what we are saying. We are saying that something should be investigated by the appropriate authority and necessary sanctions be given following the law.
You know, this is not the first time we're saying quarrel over the resolutions of either the House or the Senate. Last time we saw it on Maina's case when the Senate President did say very loudly that the executive will have to choose between the Senate and Maina. So it's like we've seen this friction over and over again concerning the resolutions of the National Assembly. How do you think that we can resolve this? You know, the executive can show a sign of not ignoring it, but maybe not carrying out, but saying that I have taken cognizance, or we have taken cognizance of your resolutions.
Yes, just like the issue of Maina, we're talking about corruption. Corruption. The Senate said this man has refused to appear to answer questions on issues of corruption. And we have said, arrest him. And he could not be arrested. So you see, it was a clear thing. It was a clear issue of corruption. So you don't need, and they have not said Maina had been convicted. They are saying, come and answer questions, and nobody could see Maina. And Maina was a civil servant as at that time, although now suspended. So you see, their own case was very clear. But this one is a case of course, they are not raising the issue of administrative incompetence. All they are raising the issue on is issue of whether she was qualified or not. And that issue of qualification, I think, is a very serious matter, too.
Because as an issue of resolutions, are you saying that each resolution would have to be examined on a case-by-case basis? Now,
resolutions, what is I think is now the issue of what is the impact, or what should be the place of resolution. Resolution of either the Senate or the House of Representatives should be accorded with great respect, but not binding on the executive. The executive should be able to say, oh, let's look at this together.
How do you think they've looked at it?
That's also another issue where the presidency or the executive may not be doing it right, or they may have been doing it without it being reported. We don't know. But we think we should also, since these things are being done in the open, they should be able to say, oh, let's look at this resolution. What are your grounds? Can we seek, even the executive on its own can go and seek the interpretation of that act, so as not to be overheating the system. I think the Attorney General should be able to say, oh, House, okay, you feel that this woman was not qualified. Let's seek for an interpretation of that provision of the act to find out whether she was qualified or not. And the executive do not have the answer. The House of Representatives may not have the answer too, but the courts will certainly have the answer.
Well, I think it looks like that will likely settle it. But the good thing is that you just raised a good point here, that she's not been asked to leave because of administrative incompetence or even corruption. Now, let's talk about corruption. The last time we spoke with Obi Ezekwesili, Nigeria's former Minister for Education and a co-founder of the Transparency International, the Global Corruption Watch, we talked about the judiciary as well, what they can do in helping to stem the scourge called corruption in our society. But quite frankly, for some, they have said that the judiciary has a greater role to play in all of this. Do you agree with that?
Yes. You see, this conversation concerning what do we do with corruption is a whole lot of conversation. Every person, including you and I, we have a great role to play in corruption. Now, but I think many of you are discharging yours. Channels, for instance, is doing wonderfully well there. But the judiciary should do more, and it can really do more. When you look at the inherent powers of the court, part of it could be when there is the issue of corruption, because corruption is an issue that affects everybody more than whatever you're doing in the court that affects two individuals. So when there is the issue of corruption, we think that the judiciary should be able to, the adjournments should not even be more than 2 weeks. And the way you have the act that says that election cases should be determined within 180 days, the judiciary on its own, without any act, should be able to say within 3 months or within 6 months, every issue bordering on corruption should be completely dealt with. And with that, you see that many of them will now come back to say, oh, let's forge ahead.
You're a lawyer.
Yes.
We've been told that, you know, corruption cases are one of the most difficult cases to prosecute because the people in question can always find ways to, you know, spurious reasons to come up with